I'm Donna Willard.
And I'm Charlie Thompson, and here's the news and a comment for bar leaders. Got a new survey. The ABA just released its bar activities inventory report. It shows the state bars and 120 local bars responding are getting to be pretty big operations. They have 1 million members. I'll tell you, since there's only 700,000 lawyers in the country, that ain't a bad record. I guess we've always been overachievers. Those local bars also have about 3,000 staff people, and together they spend over $200 million a year. We'll give you more on this study later in the program.
86% of the state bars now sponsor a lawyer impairment program, an increase of 20% since 1983. A recent addition to the growing list is the Pennsylvania Bar Association's nonprofit corporation, Lawyers Concerned for Lawyers of Pennsylvania. LCL will be comprised of volunteer lawyers and judges trained to help colleagues recover from drug or alcohol abuse. Calls will be channeled by a human services agency through a toll-free number sponsored by the bar. To facilitate information exchange among the various programs, the ABA Standing Committee on Lawyer Competence is sponsoring a meeting of Lawyer Impairment Committee chairpersons and staff Sunday morning in the Bryn Mawr Room here at the Hershey from 8:30 a.m. until noon. Charlie?
I suspect after the cocktail party Saturday night, that one will be about as empty as a bowling alley in July. Federal judicial vacancies. In a recent statement, the presidents of the 6 Mid-Atlantic state bars called the shortage of judges a state of emergency and asked President Reagan to fill federal judge vacancies. Here to report on that situation and this united call for action is Mary Ann Friedman, president of the New York State Bar Association. Mary Ann?
The Senate Judiciary Committee's slow response in filling federal judge vacancies has created a state of emergency for the federal judiciary in the Mid-Atlantic states. In a letter to President Reagan, the presidents of the New Jersey, Pennsylvania, Delaware, Maryland, and New York State Bar Associations, representing 150,000 lawyers, said that failure to swiftly fill vacant district court positions risks permanently handicapping the administration of justice. 16 of 43 vacancies nationwide are concentrated in the Mid-Atlantic states. In a united call for action, the Mid-Atlantic State Bar presidents said, if immediate action is not taken, protracted delays will be inevitable, public confidence in the judicial system will diminish, and ultimately justice will suffer. Not good. Back to you, Charlie.
Thank you, Mary Ann. State sues bar, that's no news. But bar sues state, now that's news. And that's exactly what the Los Angeles County Bar did in November. Well, if everything were logical in life, it would have been the man who rode side saddle. The bar filed suit in federal court seeking to force Superior Court officials to add more than 100 judges to slash the backlog. It's common for civil cases to take 5 years to come to trial in the county courthouse downtown. Donna?
Professionalism remains a hot topic. A number of bars, including Illinois, Georgia, and Indianapolis, have issued reports while several are putting programs in place. Both the North Carolina State Bar and the Pennsylvania Bar are developing programs to mediate differences between lawyers within law firms. At least 4 bars have developed codes of professional courtesy, including the Pulaski County, Arkansas, and Hillsborough County, Florida bars. Scheduled for the ABA House of Delegates Monday or Tuesday is a Lawyer's Code of Professionalism, recommended by the ABA Tort and Insurance section. Some will urge approval. Some may take issue with the language. Others may think that the draft should be circulated to state and local bars for comment before adoption. Copies of the proposed code are available on the table in the back of the room.
Charlie? Honesty is the best swindle. On advertising and solicitation, the latest case before the U.S. Supreme Court involving direct mail solicitation may provide a clear direction for the bar on this troubling issue. The question before the court in Shapiro versus the Kentucky Bar is the essential issue in the debate over direct mail solicitation, and that is whether a state may employ a blanket prohibition on targeted direct mail advertising by attorneys to ban a specific mailing, even though there had been no evidence that the mailing is in any way false, misleading, or deceptive. Oral arguments are set for March 1. Amicus briefs have been filed both by the ABA and the Florida Bar in support of the Kentucky Bar position. Florida has included a record of abuses established during a series of public hearings and approved funds for a scientific study of public opinions on lawyer solicitation. In the Dignity of Advertising category, the ABA Commission on Advertising is developing a document to identify aspects of advertising that lawyers should consider in efforts to develop effective advertising and marketing programs. In the coming weeks, the Commission will disseminate its proposed aspirational goals for lawyers, for lawyer advertising, to bar associations and other groups. I understand one of the things they suggest is that we only lie about the future, and when in doubt, tell the truth. Between March and June, open meetings will be held in Palm Beach, New York City, San Francisco, and Chicago to receive input on the goals before submitting them to the ABA House of Delegates. Donna?
An interesting tidbit, and perhaps a sign of things to come. The president of the Law Society of Alberta will receive a $25,000 honorarium starting in 1989. The Law Society felt the stipend would make the presidency more accessible for everyone to hold office. AIDS has become the issue of the 80s for virtually everyone. The Pennsylvania Bar Association's Task Force on AIDS sponsored a training session in December at bar headquarters, inviting each county bar president to send a representative. A major objective is to establish doctor-lawyer teams in each county to conduct community forums on AIDS. State bars in Maryland and Michigan have also formed joint committees with medical societies. The Minnesota State Legislature adopted a statute which affects people with contagious diseases. The law states that people who fail to avoid behavior which might affect others may be involuntarily confined. As a result, the Hennepin County Bar Association is considering a pilot project which would provide pro bono attorneys to serve on a commitment defense panel. This spring, the Denver Bar will hold a training seminar on AIDS, which carries 4 general CLE credits. Charlie?
Discipline and ethics. Still in the news is the California discipline case backlog. In his second report issued in November, the legislatively appointed state bar monitor criticized the discipline system as being below minimally acceptable standards. Specifically, the report criticizes resistance to a proposal to use paid administrative law judges in place of the volunteer attorneys as hearing referees. Roughly 65% of the bar's revenues support the discipline system. On other fronts, the Iowa State Senate wants to create a Department of Professionalism and to take on the job of disciplining lawyers. State Bar of Montana has presented a petition to its Supreme Court requesting responsibility for investigating and prosecuting disciplinary violations. Those tasks are currently handled through the state Supreme Court. In South Dakota, it got so cold this winter that we caught a lawyer with his hands in his own pocket. The National Organization of Bar Council issued a report last August recommending that a national reevaluation of the disciplinary system be held. ABA discipline-related committees will determine a specific course of action in response to that report this weekend.
A bill has been introduced in the Georgia legislature which would dramatically affect the unified state bar. For an update on that situation, we go to Lit Glover, president of the State Bar of Georgia. Lit?
The State Bar's Disciplinary Board received and began to process an ethical complaint which was filed against Georgia's Attorney General for certain actions that he took in his capacity as a lawyer. As a result of this, political allies of the Attorney General, including the state's Lieutenant Governor, have sponsored and introduced bills in the legislature which would abolish the unified bar and replace it with a 9-member board composed of people appointed by the state political leaders. The bill, which was proposed by State Senator Wayne Garner, an undertaker from rural Georgia, would provide for regulation of the state's 20,000 lawyers under the same type of regulatory system as undertakers and the 48 other occupations that are regulated by Georgia's Secretary of State's office. The state bar is opposing these bills on the basis that the present system is working well and is especially appropriate to deal with the bar's ethical code, which is vastly different and vastly more extensive than the simple competency test of the 48 other occupations. No vote has been taken on these bills as of this date. We'll keep you posted.
Thank you, Litt. Discipline is not the only area of dissatisfaction with the State Bar of California. Some of the local bars, primarily Beverly Hills and Los Angeles County, are questioning the responsiveness of the current state structure to the members' needs and interests. The Beverly Hills Bar has created a committee on the future of the State Bar to examine these issues. Charlie?
Remember professional services tax? Well, in August, all eyes were on the state of Florida to watch the outcome of the professional service tax battle. With the repeal of the tax January 1, it appears that the issue's pretty well been put to bed, at least during this election year. 1989, we may see more restricted bills, however, in the state legislature, exempting advertisers and exempting realtors, but not lawyers. Now here's Donna with the sports.
In the National Basketball Association last night, Indiana beat Philadelphia 109-95. It was Houston over New Jersey 115-87, and the Bucks beat the Celtics 111-101. The Lakers blew out the Clippers 117-86. In the National Hockey League, Boston over Montreal 7-3, Philadelphia over Toronto 6-1, and Pittsburgh over Minnesota 1-0. The All-Star game in the NBA is scheduled for this Sunday, 12:45 Eastern Standard Time. Athletes are gathering at the Olympic Village as the Olympics get set to open in Calgary. The Olympic torch, on its longest journey ever from Greece, is traveling through the 10 provinces and 2 territories and is set to be lit at the opening ceremonies February 13th.
Now on the weather scene, Philadelphia, clear and sunny, temperature 27, humidity 54%, barometric pressure 30.19. Miami, rain late today, high 78, low 67. Alamo, Tennessee, 37 degrees and sunshine. Houston, Texas, rainy and cold, high 38, winter storm coming in tomorrow. Lafayette, Indiana, blue skies and bitter cold, high of 18 today. Anchorage, light snow and 21. New Iberia, Louisiana, stormy as rain develops, may have a little ice by milking time in the morning. Los Angeles, sunny and mild, high of 78. The one you've been waiting for, Pierre, South Dakota, 2 below, snow flurries, wind out of the northwest at 35 knots. That'll keep the riffraff out. Donna?
He's a hard act to follow. At least 24 bar-related programs are responding to the legal needs of immigrants created by the 1986 Immigration Reform and Control Act. Here to discuss its program is Drew Ramey, Executive Director of the Bar Association of San Francisco. Drew?
In San Francisco, we have a very elaborate in-house volunteer legal services program, and it trains lawyers who don't even know where the courthouse is how to responsibly represent pro bono clients. We were approached last year by a consortium of foundations who asked us to oversee the provision of legal services in San Francisco to all of those seeking help under the legalization provisions of the '86 Immigration Act. So what we did was to hire a lawyer who was very experienced in immigration and a bilingual, experienced legal interviewer who'd been with our LRS and set up the program. At this point, we've handled about 1,000 people who have called for assistance, and about 200 of those are active cases. We've trained about, I'd say, I guess, 200 lawyers and paralegals who provide these services. And we've put together an employer advice hotline and have served about 400 employers who've called us. We see this as a model program, and we've put together, as usual, a lot of paper. We have all kinds of documents and instructions on legalization, both for the clients and for the lawyers and paralegals who handle these cases. And we'd like to export this. So if your bar is interested, please call us at the Bar Association. Amy Joseph is the lawyer in charge of it, and we'd be happy to send them to you.
Thank you, Drew. An ABA brochure applying for legalization under the new immigration law is available for bulk distribution in your community. It might be worthwhile noting as well that the absolute deadline for applying for amnesty under the program is March of 1988. Charlie?
Professional liability insurance. More state bar associations are jumping on the captive insurance company bandwagon. I guess under the theory that you gotta dip your bread in the gravy while it's hot. But the Alabama State Bar is asking for contributions of $125 to apply to startup costs for a captive. The Illinois State Bar Assembly voted in November to form a captive and hopes to get insurance out by April. The Florida Bar has also begun capitalization efforts for a captive, and ALPS, the multi-state captive, is still in the process of completing its capitalization. California is determining what a mandatory professional liability plan would look like. The State Bar recently received the results of a legislatively mandated survey asking attorneys for their opinion on mandatory insurance and the extent of their present coverage. The State Bar will submit a report with recommendations to the legislature in the spring. With the significant increase in professional liability insurance rates, many lawyers are choosing to go bare. What a sight that must be. Washington State estimates that 30% of its attorneys are uninsured. Wyoming estimates a third, and California almost a half, based on a recent survey. Donna?
30 states have adopted mandatory continuing legal education programs, North Carolina and Oregon being the most recent to join the fold. Also, the Arkansas Supreme Court raised bar dues in anticipation of approving MCLE in that state, while California is expected to recommend legislation for an MCLE program to begin in 1990. The New Hampshire Bar Association is surveying its members on the concept and operation of MCLE programs and expects to report its recommendations by June of this year. In other matters, the Florida Bar petitioned its Supreme Court in November to require all lawyers to complete an intensive study of the practical aspects of the practice of law. New lawyers would have to complete at least 23 hours of basic skills training on 11 different subjects. Currently, 9 states have mandatory basic skills courses, and 2 others require completion of a mandatory clerkship program. Charlie?
At least 21 states have formed a task force together and study gender bias in the courts. In New Jersey, the first to issue a report, the task force has targeted spousal and child support awards as a subject for the study. Information on task forces around the country and other data on this topic may be obtained from the National Judicial Education Program in New York. The ABA Commission on Women in the Profession will conduct hearings at the Franklin Plaza Hotel Saturday and Sunday. The purpose is to study the current status of women in the legal profession, identify problems specific to women, and to solicit recommendations for ABA action.
Mandatory pro bono made headline news in Maryland with a proposal to make Maryland the first state requiring attorneys to accept at least one free case a year. For an update on those developments, let's go to Cleve Miller, President of the Maryland State Bar Association, for his report. Cleve?
Thank you, Donna. Mandatory pro bono is a big issue in Maryland. A blue ribbon commission consisting of lawyers, legislators, and laypersons has issued a report that demonstrates the real and growing need for increased legal aid. As you know, Donna, the federal cutbacks in funding have really hurt in this area. One of the numerous recommendations, in addition to mandatory IOLTA, is mandatory pro bono. The recommendation is that each lawyer in the state of Maryland would be required to handle one pro bono case per year. Some of the members of our state bar are not enthusiastic about this proposal. They point out that most lawyers in Maryland do provide pro bono services on a voluntary, if not a mandatory basis. They are also concerned that another bureaucracy may be created that would assign cases to lawyers for which they are not experienced. Select committees of the Rule Committee of Maryland's highest appellate court and of the Maryland State Bar Association are now studying this issue. Keep in touch with them. I'm sure there'll be further developments.
Thank you, Cleve. We understand that North Dakota is considering a similar proposal, which includes a, quote, buyout, end of quote, option. At least 6 local bars have adopted a mandatory pro bono requirement for membership. The Greenwich Bar in Connecticut was the latest addition to the list. Charlie?
I don't know, Donna. Mandatory CLE, mandatory pro bono. If you look out there, there's 300 lawyers sitting there in blue blazers and gray slacks saying to themselves that individuality is the key to success. On tort reform, the AMA's medical liability proposal is calling for the abolition of malpractice jury trials, and it met with mixed reaction from the ABA, as you might imagine. President McCrate, in his January 13 statement, expressed concern over the creation of a new administrative agency with exclusive jurisdiction over patients' claims as well as doctors' conduct. He did, however, credit the AMA for addressing malpractice and strengthening state medical disciplinary boards. Donna?
The technology surrounding human reproductive alternatives has raised a whole host of ethical, legal, and social issues. Disputes involving surrogacy are not merely a matter of breach of contract. The Illinois State Bar's Task Force on the Family will tackle some of these issues at a national symposium the end of April in Chicago. Among topics to be discussed are alternative family forms, bioethics, surrogacy, and alternative dispute resolution. A byproduct of the conference will be legislative recommendations to bring the law up to date with the technological and social developments of recent years. Charlie?
The Dallas Bar published a brochure called Minority Lawyers in Dallas, Texas. That's to provide pertinent information to minority law students in the city of Dallas and in legal practice there. The brochure has been disseminated to over 40 law schools nationwide. The National Conference on Minority Lawyers in the Work of the Organized Bar will be held May 18 through 20 in Dallas. The conference is being co-sponsored by the ABA Section of General Practice and the Commission on Opportunities for Minorities in the Profession. State and local bar leaders will receive invitations to attend.
Over 400 alternative dispute resolution programs exist in 47 states. The Los Angeles County Bar successfully sponsored legislation to promote and finance ADR programs on a statewide basis. All of the bar's ADR activities have been consolidated under a newly created 501c3 corporation. Last November, the Minnesota State Bar Association sponsored an ADR week with the state government. For a report on that program, we go to Helen Kelly, State Bar President from Minnesota, for an update. Helen?
Thank you, Donna. Just as Minnesota is a world leader in baseball with its world champions, the Twins, Minnesota and the Minnesota State Bar Association are leaders in the area of the use of alternatives for resolving disputes. And a perfect example of partnership that Minnesota and the Minnesota State Bar Association have in this area is the Dispute Resolution Week, which we had November 15th through 21st in 1987. This is the second time that Minnesota and the State Bar Association have partnered up to give a statewide focus. About 4 years ago, we had an entire month dedicated to dispute resolution. Governor Perpich of the state of Minnesota issues a proclamation each time to give that statewide recognition. We have lots of other events that get scheduled, including during our Dispute Resolution Week. We had a public officials forum. We had a CLE programming. We had court settlement programs throughout the state of Minnesota. We had information booths in shopping centers, at colleges, and in government centers. We had public service announcements on radio, television, and also bus ads. We had special law school classes, training programs for family and farm mediators, open houses at neighborhood ADR programs, and the list goes on. Due to the great success of this joint partnership between the state and the State Bar Association, plans are underway for another Dispute Resolution Week in 1988, probably in November. We will report on that matter at that time. Thank you, Donna.
Thank you, Helen. The ABA Standing Committee on Dispute Resolution has published the ADR Primer, answering 21 questions most frequently asked by lawyers and judges about ADR processes. A workshop for state and local ADR chairpersons is being planned for next October in Chicago. We will learn more about this subject later in the morning from the local bars which have sponsored successful Settlement Week programs. Charlie?
On the IOLTA front, evidently third time is charm. The Pennsylvania Bar's House of Delegates approved a voluntary IOLTA program at its meeting in November. Apparently there was some concern that state legislation would impose an IOLTA program and that action by the court on a voluntary program was preferable. Remember, Mark Twain said, "Nothing so fortifies a man's thinking as knowing he'll be hung in a fortnight," and I suspect that was the case there. They say at least 80% of the money will be generated and earmarked for legal services programs. A bill which would divert all IOLTA funds under Arizona's mandatory program to the general fund of the state rather than to the Arizona Bar Foundation was tabled in Senate Judiciary Committee 2 weeks ago. The State Bar waged a massive media campaign to thwart that measure. Donna?
The controversy concerning membership in private clubs is still alive and well. The New York Court of Appeals has ruled that the City of New York has a legitimate interest in ensuring equal access to public accommodations. Upholding the constitutionality of a local ordinance, the New York Athletic Club has in effect lost its status as a private club. Amicus briefs on behalf of the city were filed by the American Bar Association. The case is currently on petition for certiorari to the United States Supreme Court. In chilling news from California, a state court has ruled that a coroner has no right to the head of a deceased woman decapitated and preserved under a cryogenics program, absent a showing that there was reasonable cause to suspect an unnatural death. Needless to say, this is not a dead issue.
On the literacy front, I don't expect my kids to be geniuses, but I'm getting kind of tired going to the PTA meetings under an alias. So I was proud last year when ABA President Thomas emphasized literacy as his presidential program. Stay tuned tomorrow morning for an update on Bar Association literacy programs around the country. Handouts will be available, including the just-released Bar President's Resource Book for Literacy Leadership. In fact, literacy's even hit South Dakota. South Dakota State football players now have to take a college entrance exam. A local boy went up there last week, and the coach told him, he said, "Your entrance exam, however, is a little bit different." Said there'll only be 3 questions. I'm going to tell you the questions now. You get to go home and study them for 24 hours and then come back. Said, "Here are the questions. The first question is, how many days of the week start with T? Second question is, how many seconds are there in a year? The third question is, how many D's are there in Rudolph the Red-Nosed Reindeer?" Our boy went home and studied hard. He came back and he says, "Coach, I'm ready." The coach says, "All right, how many days of the week start with T?" He says, 2. He says, "That's great. What are they?" "Today and tomorrow." Well, we'll go to the harder question. How many seconds are there in a year? There's 12. How did you figure that? Well, there's the 2nd of January, 2nd of February, 2nd of March. Go on to the third question. How many D's are there in Rudolph the Red-Nosed Reindeer? There are 306. How'd you figure that out? Dee 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 dee. No. That's all our news and the comments from KNCBP.
Good morning, Shirley.